Welcome to this episode of Term Talk, a video podcast that analyzes recent Supreme Court opinions important to the lower courts. I'm Beth Wiggins, Director of the Research Division at the Federal Judicial Center. In this episode, we discuss recent opinions implicating the First Amendment religion clauses. Mahmoud versus Taylor considers the extent to which school curriculum must accommodate religious preferences. Catholic Charities takes a close look at how statutes requiring determinations of religious purpose should be interpreted to avoid entanglement in unconstitutional religious questions. To help us analyze these opinions, I'm pleased to welcome Erwin Chemerinsky, Dean, and Jesse H. Choper, Distinguished Professor at University of California, Berkeley Law School, and Paul Clement, former U.S. Solicitor General and founder of Clement and Murphy, LLC. Thank you in advance for sharing your expertise with us today. So, Erwin, in Mahmoud versus Taylor, the plaintiffs asserted that public school curriculum violated their religious beliefs and there were no opportunities for parents to opt out of the instruction. Can you help us understand what's happening in this case?
Montgomery County, Maryland's public school system is one of the largest in the country. It is a very diverse population, and they wanted to make sure that the curriculum reflected the diversity of the population. And so part of what they did was adopt a curriculum in language arts, also for books in the library, that portrayed gay, lesbian, transgender individuals in a favorable light. One of the interesting things about the case is both Justice Alito's majority opinion and Justice Sotomayor's dissent spent a good deal of time talking about the books and how to perceive them. And they have somewhat different views of how we should look at those books. Initially, the school system allowed parents to opt out of this curriculum, but then they said this was just too burdensome. So parents of some young children brought a challenge to this. They said that they should have a First Amendment right under the Free Exercise Clause to notice as to the material and to opt their children out. On the other hand, the school system said this is a curriculum about tolerance, and a public school system can't realistically operate on a cafeteria basis where parents have the opportunity to pick and choose what their children will be taught. The Supreme Court, June 27th, in a 6-3 decision, ruled in favor of the parents and against the school system. Said Justice Alito wrote for the court, Justice Sotomayor wrote for the dissent.
So, Paul, can you tell us how the majority reached its conclusion?
The court looks at this case through the lens of one of its famous and somewhat controversial religious liberty cases, the Employment Division against Smith case, where the Supreme Court, in an opinion written by Justice Scalia, said that a neutral law of general applicability is subject to really only rational basis review, even if it substantially burdens religious exercise. And I've often described that opinion by Justice Scalia as sort of most conservatives' least favorite Justice Scalia opinion. And the Supreme Court has wrestled with the question of whether they should overturn the Smith decision. They had a case a few terms ago called Fulton against the city of Philadelphia, where the court substantially cut back on the reach of the Smith decision and essentially kind of redefined what it means for a law to be neutral and generally applicable, and in a way that I think practically means that more laws will be subject to strict scrutiny and less laws will be subject to the rational basis rule of Smith. But here, this case still looked like it was going to be applicable as a neutral law of general applicability. That's the way that the lower courts processed the case. And so what the majority did in this case is to fashion, at least to what my eyes looks like, to be a new exception to the Smith test. And that is for laws that impose a Yoder-like burden on religious exercise. And just to be clear what that means, that's not a reference to Star Wars, that's a reference to the Supreme Court's Yoder decision, which involved a compulsory education law and the opportunity or the effort of Amish parents to have their kids not have to go to high school, but to opt out from that because they felt like the local high school would inculcate values that were contrary to the Amish religion, would make it harder for the Amish parents to raise their children in the faith. And that's a decision that actually predated Smith. And so the Smith decision, the majority and concurring opinions in Smith wrestled with what to do with the Yoder decision. But the Yoder case has always been understood as a law that gave a right to religious exercise that was something of an exception to Smith. And this decision, I think, expands that and says whenever the religious parents can try to describe the burden on their religious exercise, not just as an ordinary burden, but a Yoder-like burden on their religious exercise, that will be enough to trigger strict scrutiny. And then once you get to strict scrutiny, the majority made relatively sort of short work of the particular program here. And I think, this is a situation where the facts of this case, once it got to the Supreme Court and once the Supreme Court decided to apply strict scrutiny, really did work against the school district. Whatever result you might have imagined in a situation where the school district from the beginning didn't allow an opt-out and was insisting in the Supreme Court that allowing an opt-out was fundamentally incompatible with the educational program. Having granted an opt-out for a year and, essentially have an experience where lots of parents opted out, I think those facts really hurt the school district once they got to the Supreme Court and once the majority of the Supreme Court decided they were going to apply strict scrutiny.
So, Erwin, what did the dissent say?
Justice Sotomayor wrote the dissent. It was joined by Justice Kagan and Jackson. Justice Sotomayor says, never before in history has the Supreme Court held that mere exposure to material is enough for a violation of free exercise of religion. Justice Sotomayor says, this is the classic neutral law of general applicability. The curriculum wasn't set out of a desire to interfere with religion. There was no animus against religion animating the curriculum, and it applies to everyone. So Wisconsin versus Yoder is a very narrow exception that allowed Amish parents to exempt their children after 8th grade from compulsory schooling. Says it doesn't carry over here. But I think most important what Justice Sotomayor says is, and I'll quote her word, that this is a decision that's going to cause chaos in the public schools. She said, our country is so diverse with regard to its religious population. How are schools going to know when they have to give notice to parents? And what will it mean that parents can opt out for their children of any material they find objectionable on religious grounds? So does this mean that every time evolution is taught in a biology or a science class, parents have the right to notice and opt out? Does this mean that any time in an English class there's books about witches or witchcraft, like Harry Potter, parents have the right to notice and opt out? Justice Sotomayor gives the example and says, some religions believe that mothers should not work outside the home. Does this mean that any time there's a history book that portrays a working mother in a favorable light, parents have the right to notice and opt out?
We'll just stay with you for a minute, Erwin. What are the key takeaways for the lower courts?
The first is that there's not a cabining principle in Justice Alito's majority opinion. It seemingly says that anytime parents have a religious objection to material that's taught in public schools, they have the right to advance notice and to opt out. That's going to be a very difficult rule to administer, and I expect there's going to be a lot of challenges brought to particular aspects of curriculum based on this. And second, I think this is a further erosion of employment division versus Smith. As Paul pointed out in Fulton versus City of Philadelphia, 3 justices urged the immediate overruling of that decision. 2 others said they were sympathetic, but didn't need to in that case. But the court chipped away at employment division versus Smith. Wisconsin versus Yoder was recognized in employment division versus Smith as an exception to the rule. Now that exception has grown.
How about you, Paul?
I think the interesting thing going forward is just, how much is left of employment division versus Smith, and is there really going to be anything left for the Supreme Court to overrule? And by the last question, I really mean, at a certain point, I think if Smith is really the dominant rule, then and most of these policies that burden religious exercise are going to be subject only to rational basis, then I think a court that seems quite sort of receptive and amenable to religious liberty claims is almost certainly going to overrule Smith at some point. On the other hand, if Smith really only applies to a small category of cases where there's no possibility of the government giving exceptions and things, the burden on religious exercise has to be only a sort of a theoretical one, not as substantial as the burden in this case, then Smith may end up being less the default rule and the rule for a category of cases where maybe the majority of the court will be comfortable with the government winning. So I think that's really, those issues will play out in the lower courts. Obviously, nobody thinks the lower courts themselves can overrule Smith. So I think most of these cases, as they go through the lower courts, will really focus on the breadth of these exceptions. And this could be a situation where the court ultimately decides that the exceptions have made the rule of Smith unworkable and therefore give the basis for overruling Smith, or they could ultimately lead to a situation where overruling Smith just doesn't become as important as most people thought it would be.
Catholic Charities versus Wisconsin was a unanimous decision that clarified the narrow meaning of religious purpose. Can you tell us more about the facts of this case?
Sure, I'd be happy to. And the Wisconsin statute here is one that is, it was specific to unemployment tax. It was a state law, but it certainly doesn't stand alone. This is not one of those religion cases where some jurisdiction does something very unusual. Wisconsin, by exempting sort of religious entities from the unemployment law, is doing something that the federal government does, that most states do, and then essentially every state does in some context. In a lot of contexts, property taxes and the like will have an exception for religious uses of property and the rest. And so this is a common feature. And the question here as it arose was really whether the particular characteristics of the Wisconsin Catholic Charities made it somehow inapplicable, the exception inapplicable to Wisconsin Catholic Charities. And as the case worked itself through the lower courts and in the state court system in Wisconsin, there were really kind of two issues. One was whether to think of the Wisconsin Catholic Charities separate from the rest of the sort of Catholic diocese in Wisconsin. And then the second question was to focus on how the Wisconsin Catholic Charities operated. And in particular, the fact that when it came to employing people to do Catholic charities, there was no denominational preference. So you could have people working at Catholic charities who had no religion or a different religion than the Catholic Church. And then, of course, in supplying the services to people, there was also no denominational preference. So they were perfectly happy to provide shelter to the homeless without regard to whether the homeless were Catholic or not. And they also had a policy where they really weren't involved in directly proselytizing the people that they were providing social services to. So if they operated a shelter, they wouldn't sort of have, sort of mass 6 times a day or something as part of the charitable services. And it is because of those features of the law that I think the courts in Wisconsin essentially decided that the Catholic Charities operated really more as a provider of secular services, didn't operate in a way that was distinctly religious, such that they came within the religious exemption. And the Wisconsin Supreme Court denied the applicability of the religious exemption on those grounds.
The U.S. Supreme Court reversed 9-0. So, and Justice Sotomayor wrote the opinion for the court. So where did they think the Wisconsin Supreme Court got it wrong?
Maybe I'd be most helpful by putting this in the context of how the Supreme Court's jurisprudence with regard to the religion clauses is changing. For decades, the Supreme Court had taken a minimalist approach to the free exercise clause, is reflected in Employment Division versus Smith. But as Paul and I have been talking about, the Supreme Court has been backing away from that and taking a more robust approach to the Free Exercise Clause. At the same time, for decades, the Supreme Court took a robust approach to the Establishment Clause. It saw the Establishment Clause as reflecting the words of Thomas Jefferson, through a wall that separates church and state. I think of 20 years ago, Paul and I arguing against each other in the Supreme Court in a case that involved whether a Ten Commandments monument on the grounds of the Texas State Capitol violated the Establishment Clause. But in recent years, the Supreme Court has taken a very minimalist approach with regard to the Establishment Clause. Some justices said that the Establishment Clause is violated only if the government coerces religious participation. Well, it's in this context that this case was potentially so significant. And what Justice Sotomayor did was rely on a well-established principle. If the government discriminates among religions, then the government is going to have to meet strict scrutiny. The Supreme Court held this previously in Larson versus Valente and other cases. Justice Sotomayor says here, the government is discriminating among religions. If, for example, Catholic Charities, as part of the service provided, proselytized its religion, then under the Wisconsin Supreme Court approach, it would be said of a religious purpose. Or if Catholic Charities discriminated based on denomination and who it would provide services to, then it would have a religious purpose. She said, when the government is discriminating among religions like this, it has to meet strict scrutiny. And she said the government failed to meet strict scrutiny in this instance.
So Paul, there were also two concurrences. What points did they emphasize?
Sure, there were two concurrences here, and they were lengthy concurrences. This isn't a situation where a justice just adds a couple of words to the majority opinion that they're joining. Justice Thomas wrote separately to address the question that was lurking in the case that the majority didn't address. As I mentioned, there are kind of two questions in the lower courts. One was, do you look at just Wisconsin Catholic Charities, or do you look at the broader sort of diocese or the Catholic Church? And then the second question is, okay, if we're going to look only at Catholic social services, then is that something that has a religious purpose? And Justice Thomas wrote separately really to address that first question, to say that although he agreed with the court on the resolution of the second question, he would have actually also agreed with the church or ruled with the church on the first question and said, really, you don't look at Catholic social services separately, or Catholic charities rather separately from the broader church. And if you look at it from the perspective of the broader church, then it's a very straightforward case. Justice Jackson, I think, wrote separately really to come at this in a way that suggests that she was with the majority on this, but might have a narrower view in a future case, and really focused on what's the right way to analyze an organization as to whether or not it's providing religious service or has a religious purpose. And she said, rather than look to sort of purpose, it really is kind of better to have a more objective focus on what the organization just actually does on a day-to-day basis. And in doing so, she drew quite a bit from the legislative history of the federal statute and the federal exception. And so I think I read her separate opinion as to have an eye toward, the next case that might involve an application of the federal unemployment tax.
So Paul, staying with you for a minute, what do you think the key takeaways for the courts are from this opinion?
So I guess my thought about this opinion is this is a case where seemingly this looks like it was an easy case for the court. It was decided unanimously. I will say that, I almost never predict outcomes in Supreme Court cases, but once the court took this case, I was quite sure they were going to reverse. And I just think, the idea that, something like Catholic social services is not subject to a religious exemption seems pretty counterintuitive. Maybe I'm projecting the fact that I'm a Roman Catholic who grew up in Wisconsin. But I certainly, growing up, would have thought that the Catholic Charities of Wisconsin was a religious organization. But I guess what I would really want to emphasize here is this is one of these cases, and you often see this, where there are some really hard questions that are obscured by the unanimity of the court. Or another way to put it is, maybe, there's a couple of 5-4 or 6-3 decisions down the road lurking in this 9-0 resolution. And the reason I say that is because there are a number of laws on the books that do provide special treatment for religious organizations. And indeed, there's aspects of the Supreme Court's own jurisprudence, like the religious autonomy doctrine, that provide certain exceptions, exemptions for religious groups from laws. And I think Erwin was alluding to this. Some of these doctrines giving exceptions to religious organizations have kind of doctrinally come up on a separate path from the Employment Division v. Smith. It's as if the Supreme Court itself is creating laws that are no longer neutral and generally applicable. So I sort of see two things coming. One is at some point there's going to have to be a reckoning of sort of these various lines of Supreme Court jurisprudence. But the second thing, and this is really where I say there are some hard questions lurking here, you can't have multiple laws that give special treatment to religious groups without having some coherent way of deciding what's a religious group and what's just a secular charity group or a secular group that has sort of principles of organization that aren't religious principles of organizations. And all of those are hard questions. And frankly, it's a little hard to see how you draw the line between religious organizations and non-religious organizations without creating something that's going to look a lot like a denominational preference. And yet this decision says that anything that looks like a denominational preference is going to be subject to strict scrutiny.
So, Erwin, what would you add?
I very much agree with everything Paul just said. An interesting fact, this is only one of 3 cases all term where the Supreme Court was reviewing a state court decision. All the other cases on the docket came from the federal courts. And so I agree with Paul. Once the Supreme Court took it, it was an indication it was not going to affirm. Let me add 2 things to what Paul said. One is I think this shows an area where the establishment clauses can continue to be very important. I had mentioned how the Supreme Court is taking a much weaker, more deferential approach with regard to the establishment clause. But this says if it is discrimination among religions, it's going to continue to get strict scrutiny. The second really goes to what Paul was saying in terms of the cases to come up in the future. One of the hardest issues under the First Amendment that the Supreme Court has never tackled is trying to define what is religion or what is a religious purpose. And there's a good reason why the Supreme Court doesn't want to take on that issue. But the more the Supreme Court backs away from Employment Division versus Smith and creates exemptions for religion, the more the Supreme Court's going to have to define what's religion. The underlying issue in this case is the language in the Wisconsin statute that gives an exemption if it's for a religious purpose. And the Supreme Court stayed away from that, but it's not going to be able to do so very long given the direction of its jurisprudence.
So let's briefly talk about a third religion case, Oklahoma Statewide Charter School Board versus Drummond, which was decided 4-4 without Justice Barrett participating. So I guess I'd throw this question out to both of you. Where do you think the court might go if this issue rises again and is heard by the full court?
Sure, I'll take the first crack at this. I mean, as you say, I think at the beginning of the term, I think Erwin and I probably both thought we'd be talking about 3 big religion cases, and maybe the biggest of them all would be this question of whether or not a state can permissively have so-called religious charter schools. There's been a lot of debate over the years about the constitutionality of school choice and the like. And at the same time that debate has happened, charter schools have arisen as kind of innovative alternatives to the traditional public schools. But I think most people have thought about the charter schools as being just an innovative form of public school. And then when a state like Oklahoma says we're going to allow the charter schools to be religious if they want to on an open basis, but we're going to allow such a thing as a religious charter school, well, then it really raises the question. I mean, if charter schools are public schools, can you really have a public school that is essentially being run as a religious school or as a religious enterprise? And that's the question that was up before the court. As he said, the Supreme Court divided evenly 4-4, leaving a lower court opinion that struck down the program in place. But the real headline was that Justice Barrett recused herself from the case. And so this issue will almost certainly return to the Supreme Court. And if the composition of the court remains the same, Justice Barrett would seemingly have the decisive vote in the case. I guess I would just say one thing about this case. We obviously don't have an opinion to analyze or anything like that, so I'll keep it brief. But I do think in some ways the question here is as much about what is the nature of a charter school as it is about sort of the religion clauses and the rest. And they will certainly be a focal point. But I don't know that the court has ever really had to wrestle in quite the same way with what makes a public school a public school. And at what point do you allow so much experimentation and kind of distinctiveness of the charter schools that they sort of become something else? And I think in order to try to say how you could have a religious charter school consistent with the Establishment Clause, I do think you need to argue that the charter schools really are very distinct from the traditional public school. And so that question of like, what is a charter school and what is a public school? I think those are the questions that are really going to be among the focal points for the Supreme Court when this issue returns.
I very much agree with Paul. Let me put it in a different context, though. Over the last 8 years, there have been a series of cases from the Supreme Court holding that the government violates the Free Exercise Clause, provides benefits to private secular schools that denies to religious schools. Trinity Lutheran versus Comer, Espinoza versus Montana Department of Revenue, Carson versus Macon. So it was inevitable after these cases, the issue was going to come up. Well, what about charter schools? Virtually every state has charter schools. In virtually every state, the law says that the charter schools have to be secular. Charter schools are created by state law. They're funded by the government, but they're privately run. And so as Paul just said, it's really the question of, should we think of charter schools as public schools? And then can we possibly tolerate religious public schools? Or on the other hand, should we think of them as private schools, in which case denying the funding violates free exercise of religion? This was the issue that was before the Supreme Court. As you said, it's split 4-4. You ask for a prediction. I think when it comes back, it's going to be 5-4 with Justice Barrett in the majority.
Thank you both for joining us for the discussion today.